Good day, Attorney Aquino and classmates. We are Group 10 and we'll tackle Article 3, Sections 21 and 22, and some cases under Article 4. So I am Julian Capili and I will be your first reporter. So I'll tackle Section 21 or a double jeopardy, which provides that no person shall be twice put in jeopardy of punishment for the same offense if an act is punished by a law and an ordinance conviction or acquittal under either shall constitute a bar to another prosecution for the same act. Okay, for my first case, it's Merencillo versus People. So the facts are as follows. So there are two information that were filed against Juanita Merencillo. One is a violation under RA 3019 or anti graft and corruption practices and Article 210 or direct bribery of the revised penal code. So what happened is in this case is that on September 13, 1995, Estolier went to the Bureau of Internal Revenue Office in Tagbilaran City in order to ask the computation of the taxes due on the sale of the real property to Ramansolio Super Studio and also to apply for a certificate authorizing registration. Her documentary stamps and capital gains were computed and was approved by the petitioner as he is the group supervisor. Estolier then paid the taxes in the bank and submit the applications and documents to the car. And on the same day, Maria Angeles Romanzola Cesar or Cesar received a call from Estolier, and she was told that the petitioner wanted to see her for some negotiation, and thereafter, the petitioner went to the office of the petition. Cesar rather went to the petitioner's office, and the petitioner then demanded 20,000 pesos in exchange for the approval of the car. And on September 20, 1995, Cesar was able to return to the BIR, and again, the petitioner demanded 20,000 pesos. So, 2 days after Cesar visited the RDO of Balagon and complained about the petitioner's refusal to release the car unless his demands were met. The petitioner called Cesar, informing that she could get the car, but reminded her of his demand. He told her that he was willing to accept a lesser amount, and thereafter, an entrapment operation was made by the PNP, and thereafter captured Merencillo. Okay, so for the issue, it is whether or not there is a double jeopardy when the petitioner was charged with violation of Section 3, Paragraph B of RA 3019 and direct bribery under the revised penal code. So the Supreme Court ruled that the petitioner was not placed in double jeopardy. Under Section 3 of RA 3019, it begins with the following statement. In addition to acts or omission of public officers already penalized by existing laws, the following acts shall constitute corrupt practices of any public officer and are hereby declared unlawful. Further, one may be therefore charged with a violation of RA 3019 in addition to a felony under RPC for the same delictual act. That is either concurrently or subsequent to be charged with felony under the revised penal code. So the rule against double jeopardy prohibits twice placing a person in jeopardy of punishment for the same offense. And the test is whether one offense is identical with the other or is an attempt to commit it or frustration thereof, or whether one offense necessarily includes or is necessarily included in the other. So herein, the elements of the crime of direct bribery get defined and punished under the revised penal code, and those of a violation of the RA 3019 shows that there is neither identity nor necessary inclusion between the two offenses. Thus, although the two charges against petitioner stem from the same transaction, the same act give rise to two separate distinct offenses. No double jeopardy attached since there was a variance between the elements of the offenses charged against the petitioner. Okay, moving on to section 22, or ex post facto or bill of attainder. So section 2 provides that no ex post facto or bill of attainder shall be enacted. Okay, for the case under section 22, my case is United States versus Conde. So the facts are as follows. On December 30, 1915, alleged offended persons Bartolome Oliveros and Engracia Lianco executed and delivered to the defendants a contracting evidence that the fact that the former had borrowed from the latter the sum of 300, and that by virtue of the terms of the said contract, Oliveros and Lianco obligated themselves to pay to the defendants interest at the rate of 5% per month, payable within first 10 days of each and every month. The first payment to be made is on the 10th day of January 1916. Okay, moving on to the issue of this case, show whether or not the usury law applies to the case, even that the parties entered into the contract on December 30, 1915, and the usury law took effect on May 1st, 1916. Okay, so the Supreme Court ruled that the usury law is not applicable at this case because Act number 2655 made an act which had been done before the law was adopted. A criminal act and an act, and to make an act applicable to the act complained of would be to give it an ex post facto operation. The legislature is prohibited from adopting a law which will make an act done before its adoption a crime. A law may be given a retroactive effect in civil action, providing it's curative in character, but ex post facto laws are absolutely prohibited unless it is retroactive effect is favorable to the defendant. For the reason, therefore, the acts complained of in the present case were legal at the time of their occurrence, they cannot be made criminal by any subsequent or ex post facto legislation. So those are my cases. Thank you so much. And next reporter is Miss Santiago.
Hello, attorney. I am Duchess Patricia R. Santiago, and I will be discussing two cases under Section 22 of Article 3 of the 1987 Constitution. Now, to better jog our memories, such provision states that no ex post facto law or bill of attainder shall be enacted. As we all know, an ex post facto law is one which retroactively makes criminal conduct that was not criminal when performed. It increases the punishment for crimes already committed, or it changes the rules of procedure in force at the time such crime was allegedly committed. On the other hand, a bill of attainder is a legislative act which inflicts punishment without trial. In other words, it violates a person's right to due process. For the first case at hand, we have Concepcion versus Garcia, the doctrine being that ex post facto laws do not apply to remedial laws or civil laws. Firstly, because a person has no vested right in any particular remedy, and a litigant cannot insist on the application to the trial of his case, whether it be civil or criminal. Ex post facto laws also do not apply to civil law because it is not penal in nature. It has long been settled that the phrase quote unquote ex post facto laws is not applicable to civil laws, but to penal and criminal laws, which punishes a party for acts antecedently done, which were not punishable at all or not punishable to the extent or in the manner prescribed. In short, ex post facto laws relate to penal and criminal proceedings only and not to civil laws. So the facts of the case are as follows. Government of the Philippine Islands instituted a civil action against Florencio Reyes, who was the former chief of the Stamp Division of Bureau of Posts. The former alleges that Reyes has misappropriated funds in the amount aggregating to 212,349 peso and 42 cents. In the case, an attachment against the defendant by virtue of respondent Garcia, in the capacity of deputy sheriff, levied upon certain household effects as the property of the defendant. Dominga Concepcion, on the other hand, who is the wife of Reyes, presented in writing to the sheriff a third-party claim asserting ownership in the household effects that were levied. Garcia then demanded that the government should give an indemnity bond to secure him against liability from said claim. Take note that the bond was extended as per a motion by such party. So it was extended until October 10, 1929. However, a legislative statute or act as Act number 3531 added an amendment in the form of proviso to both sections 442 and 451 of the civil procedure. It states that when the plaintiff or the person in whose favor the writ of attachment runs in the insular government or any officer duly representing it, the filing of such bond shall not be required. Such act was approved on September 28, 1929, and it took effect on October 10, 1929. So take note of the two dates from when the bond was extended by the court and to when the act actually took effect. So the issue in this case was whether or not Act number 3531 is constitutional, as the other party claims that it is an ex post facto law. The ruling of the court was yes. Act number 3531 is an act dealing exclusively with remedies and modes of procedure. Such an act is repugnant to no constitutional provision and its legality is beyond question. The act in question is not an ex post facto law, as it is not penal in its nature. It has long been settled that the phrase ex post facto laws is not applicable to civil laws, but again to penal and criminal, which punish a party for acts antecedently done which were not punishable at all at the time such crime was committed. Moving on to the second case, People versus Ferrer. The doctrine of the case is that it is only when a statute applies either to named individuals or to easily ascertainable members of a group in such a way as to inflict punishment on them without a judicial trial does it become a bill of attainder. The facts of the case are as follows. Feliciano Co. and Nilo Tayag, together with 5 others, were charged with violation of RA number 1700 or anti-subversion law by instigating, recruiting, inciting others to rise up and take arms against the government. Such organization was quote-unquote called Kabataang Makabayan. The above-mentioned act outlaws the Communist Party of the Philippines and other subversive associations and punishes any person who knowingly, willfully, and by overt acts affiliates himself with, becomes or remains a member of the party or any other similar subversive organization. Both of the accused moved to quash the informations on the ground that such act was a bill of attainder. The issue in this case was whether or not RA 1700 was in fact a bill of attainder, therefore prohibited and unconstitutional. The court ruled in the negative, saying that RA 1700, the fact still remains that their guilt has to be judicially established. Therefore, there is still due process. The government has yet to prove at the trial that the accused joined the party knowingly, willfully, and by overt acts, and that they joined the party knowing its subversive character and with specific intent to further its basic objective. It simply declared that the party communist to be an organized conspiracy to overthrow government. The accused will be tried in proper courts and there would still be a trial. Now, as well, remember, a bill of attainder dismisses or throws away the part of trial, and from then on, they will immediately determine one's guilt. The Supreme Court added that the act is viewed if the act is viewed in its actual operation, it will be seen that it does not specify the Communist Party of the Philippines or the member thereof for the purpose of punishment. In fact, the act applies not only to the Communist Party of the Philippines, but again, quote unquote, any organization having the same purpose and their successors, which in a nutshell would have the goal of overthrowing the Philippine government. Its focus is not on individuals, but on conduct. So that would be all for my part, sir. Thank you very much. Again, I am Duchess Santiago.
Today, I will be presenting cases regarding the prohibition of ex post facto law and citizenship. The first case that I will be presenting today is the one regarding Nasi-Villar versus People of the Philippines. GR number 176169, November 14, 2000. So this is a case for a petition of review under Rule 45 of the Rules of Court, assailing a previous decision rendered regarding a case filed against the petitioner Rosario Nasi-Villar for committing illegal recruitment of the respondent Nila Panilag abroad and collecting 6,500 pesos as a placement fee, and whose acts were committed back in January 1993. The petitioner, having no license to operate as a manpower agency and no authority to recruit workers for overseas work, prejudices and holds them liable for damages committed against the offending party. So, after the trial, the RTC found evidence presented by the prosecution to be more credible than that presented by the defense, and thus holds the petitioner liable for the offense of illegal recruitment under RA 8042, or the Migrant Workers and Overseas Filipinos Act of 1995. The petitioner appealed with the Court of Appeals that there was an error in the decision issued by the regional trial court, and that RA 8042 cannot be given retroactive effect, and that the previous decision of the regional trial court constitutes a violation of the constitutional prohibition of ex post facto law by finding her guilty of illegal recruitment and punishing her under the same law. However, the appellate court affirmed the decision of the regional trial court but modified it, stating that the petitioner should have been charged by the Labor Code and not Republic Act 8042. So the issue in this case is whether or not the Court of Appeals erred in failing to consider that Republic Act 8042 cannot be given retroactive effect with regard to the penalties imposed. The court ruled that no, the Court of Appeals did consider the non-retroactive effect of Republic Act 8042, and that there was no violation of the constitutional prohibition for ex post facto law as alleged by the petitioner. So the doctrine of this case is that a criminal act is punishable under the law in force at the time of its commission. The Court of Appeals ruling in modifying the decision rendered by the Regional Trial Court in applying the Labor Code instead of the more recent law was correct, as the Labor Code was given effect back in November 1, 1974. So in this case, the Labor Code was still in effect when the crime of illegal recruitment was committed by the petitioner. And the basic rule is that a criminal act is punishable under the law in force at the time of its commission. And in the case at bar, the act committed by the petitioner was punishable under Article 38 in relation to Article 39 of the Labor Code. The court held that it was proven that Nasi-Villar had committed the criminal act of illegal recruitment, which she was charged with. She was properly convicted under the Labor Code and not Republic Act 8042. So for the next case, it is regarding Article 4, citizenship. And the case that I will be presenting is regarding Poe-Llamanzares versus COMELEC. GR number 221697, March 8, 2016. So the facts of this case is Petitioner Grace Poe-Llamanzares filed two consolidated petitions under Rule 64 in relation to Rule 65 of the Rules of Court, with extremely urgent application for an ex parte issuance of temporary restraining order and status quo ante order and or writ of preliminary injunction assailing the resolutions of the COMELEC, disqualifying her from filing candidacy in the May 2016 presidential elections. So, the petitioner was born in 1968 and was found as an infant in Haro, Iloilo, and was legally adopted by Roland Allen Key Poe, FPJ, and Jesus Sonora Poe, Susan Roses. She then subsequently immigrated to the US in 1991, and after her marriage was naturalized as a US citizen in the year 2000. However, due to her father's worsening medical condition, She went back to the Philippines in 2004. And after his death, she returned to the US to settle her affairs and went back to the Philippines again on May 24, 2005, with the intention of staying in the country permanently. In 2006, she petitioned to reacquire her Filipino citizenship under Republic Act 9225 or the Citizenship Retention and Reacquisition Act of 2003. She then filed her candidacy for the May 2016 presidential elections, which was contested by the respondents, including one Estrella El Amparo, alleging the following. The petitioner had committed material misrepresentation when she stated in her certificate of candidacy that she was a natural born Filipino citizen and that she is a resident of the Philippines for at least 10 years and 11 months up to the day before the May 2016 elections. And that the petitioner cannot be considered as a natural born citizen on the account that she was a foundling, and international law does not confer natural born status on foundlings. She contends that a natural born citizen must be continuous from birth, and having been naturalized as an American citizen disqualifies her from reacquiring Filipino citizenship under the same law. So the issue in this case is whether or not the petitioner, Grace Poe-Llamanzares, was a natural born Filipino citizen. The court ruled that she is a natural born citizen of the Philippines and that her residence up to the day before the elections would satisfy the residential requirement for her presidential candidacy. So there were many facts considered by the court in the determination of her natural born status, and the most notable ones are this: that there was a high probability that her parents are Filipinos. Based on her physical features, she was found in Haro, Iloilo, and there was a 99% probability that her biological parents are Filipinos, of which the probability of 99% and the circumstantial evidence presented in court are admissible under Rule 128, Section 4 of the Rules on Evidence. And that the Supreme Court ruled that foundings are, as a class, natural born citizens, as based on the deliberations of the 1935 Constitutional Convention, wherein, through its enumeration, is silent as to foundlings. There was no restrictive language either to definitely exclude the foundings to be natural born citizens. Also, international law conventions and instruments on the matter of nationality of foundlings were designed to address the plight of a defenseless class. That these treaties and conventions are tools to be used to uplift foundlings who seek to be protected from being accorded second class citizenship and being denied political status. Finally, the last issue that the court addressed, the petitioner satisfied the 10-year residency requirement in acquiring a domicile in the Philippines because upon her return, she has presented overwhelming evidence of her actual stay and intent to permanently abandon her US domicile, as well as her application to reacquire Filipino citizenship under Republic Act 9225. Furthermore, the count of the 10-year residency period, as ruled by the court, should have started on May 24, 2005, as her return to the Philippines should have been at the start of that count. So that satisfies and proves her claim of 10 years and 11 months. So thank you for listening to my report. Next up would be one of my group mates presenting the next few cases. Thank you.
Okay, so I will discuss two cases under citizenship. So the first case is David versus Senate Electoral Tribunal. So the facts of this case are as follows. So a brief background, Senator Grace Poe was a foundling whose biological parents were unknown. So as an infant, she was at the parish church. She was found at the parish church at Haro, Iloilo. She was then found by Edgardo Militar outside the church on September 3, 1978. So he turned her over and she was given the name of Mary Grace Natividad Contreras Militar. So on May 13, 1974, the Municipal Court of San Juan promulgated the decision granting the petition for the adoption of Senator Poe by Ronald Poe, or FPJ, and Jesusa Poe. So a few years, several years later, Senator Poe went to the United States to acquire her college degree. So on July 10, 2006, she then filed a petition for the reacquisition of her Philippine citizenship. And on October 6, 2010, uh, President Benigno Aquino appointed Senator Poe as a chairperson of the MTRCB. And in 2013, Poe then decided to run as senator. So David, a losing candidate in 2013, contested at the election of Senator Poe for failing to comply with the citizenship and residency, saying that she was not a natural-born citizen of the Philippines. So Article 6, Section 3 of the 1987 Constitution states that no person shall be elected a senator unless he or she is a natural-born citizen. So the issue of this case is whether or not the private respondent, Senator Grace Poe, was a natural-born citizen of the Philippines, and if she is qualified to sit as senator of the Philippines. So the assumption should be that foundlings are natural-born unless there's evidence to contrary. So private respondents being a foundling is not a bar to natural-born citizenship, since there was no evidence found that she was born of foreigner parents. So thus private respondent lost her Philippine citizenship when she was naturalized as an American citizen on July 26, but she then took her oath of allegiance back to the Republic of the Philippines when she came back in the Philippines. So the next case is Tecson versus COMELEC. So respondent Ronald Allen Poe, also known as Fernando Poe Jr., filed his certificate of candidacy on December 31, 2003 for the position of President of the Republic of the Philippines. So in his certificate of candidacy, FPJ, representing himself to be a natural-born citizen of the Philippines, stated his name to be Fernando Jr. He also stated that his date of birth was August 20, 1939, and was born in Manila. So a petitioner Fournier filed before the COMELEC a petition to disqualify FPJ, stating that he is not a natural-born citizen of the Philippines, as his parents were foreigners, stating that his mother was an American and his father was Spanish. So the issue of this case is whether or not FPJ is a natural-born citizen and is eligible to run for president. So according to Section 2 of Article 7 of the 1987 Constitution, no person may be elected president unless he is a natural-born citizen of the Philippines, a registered voter, able to read and write, and at least 40 years of age on the day of the election. Based on the evidence presented, father of Alan Poe, who in turn was the father of FPJ, indicated that he died in September 1954 at the age of 84 years old in Pangasinan. So the residence of Lorenzo Poe was stated to be in San Carlos, Pangasinan. So the rule is, in the absence of any to the contrary, it is sound to conclude that the place of residence of a person at the time of his death was also his residence before his death. So considering that the allegations of petitioners are not substantiated with proof, there's no doubt that Alan Poe, father of FPJ, was a Filipino citizen. And since FPJ was born in 1939 and was governed under the 1935 Constitution, which Constitution considers as Filipino citizens of the Philippines those whose fathers are citizens of the Philippines. So that being said, FPJ was in fact a natural-born citizen. So that is it for my report.